Cooperating between parents who are not married, on one hand, has success stories, but on the other hand, there has been difficult and sad situation where parents are not able to peacefully cooperate and take care of their children, so that children sometimes end up being disadvantaged. Uh, Parents may be living apart, either they were never married from the beginning when the child was born, or they were married but unfortunately the marriage was dissolved, or they have separated and now they are living separately. The law envisages such a situation, so the law itself has provided a mechanism where parents should be able to cooperate as they take care of their children and provide what is required from day-to-day survival of the child. As we all know, under our constitution, a child is any person who is below 18 years, up to 18 years. But later in a different episode, we shall be seeing that that responsibility can actually be extended beyond 18 years. So the issue which arises mostly is how are parents supposed to cooperate. Three issues come up whenever there are disputes arising or touching on coparenting. One is maintenance. Maintenance of children means the day-to-day provision of a child needs, basic needs, food, shelter, education, and everything. The second issue is custody. Who should live with the child when the parents are not living together? And the third one is paternity, where one of the parents, the father, disputes that he's the biological father of the child. So those three issues are the common issues in our courts on day-to-day basis, and that's what most of our courts are struggling with to deal with or address in disputes touching on the children. Let me start by talking about maintenance. Maintenance is the day-to-day provision of a child's basic needs. Just like us adults, the children have their needs, and the larger part of it is education, food, shelter, medical, and the day-to-day survival of the child. So when parents are not living together, who has the responsibility to take care of this child? So to begin with, the protection of the children in our country is so much protected. In fact, in the Constitution is so clearly stated and dictated that the responsibility of our children is not negotiable. And what from the onset all parents should understand is that children who are born in marriages or where parents are cohabiting, and children who are born outside marriages, under the law they have the same status. In terms of care and protection, those children are of equal status, so no child should ever feel disadvantaged just because they were born in outside a marriage. So the law is very protective of the children because they are vulnerable. In fact, the Constitution itself dictates that children are vulnerable because they need of care and attention. It depends on their parents, on guardians to guide or make critical decisions on their day-to-day survival. So when it comes to provision, you'll find that so often parties are not able to agree and the matters end up to court. And the common question is how does the court decide who should bear the responsibility? So first, one thing that every person should understand, under our constitution and our children law, parties have an equal responsibility over parenting a child. Whether they are married or not is irrelevant, and that's what our constitution provides. It's very clear that the mother, the father has equal responsibility over a child, irrespective of whether they are married or not. So that even as the mother, probably when you're going to court to seek for maintenance in court, you must demonstrate yourself. What is your contribution? What is your contribution? Don't be misled that you can go to court and ask for the father to provide everything for the child. No, there is equal responsibility. You must demonstrate. If you are saying the father should educate this child, should provide for medication, you should be able at least to demonstrate either you're providing housing, food, or any other provision. It's a shared responsibility. So when these matters get to court, how does the court decide how much or at all should which party be ordered to provide for provision of the child? There are various considerations or guidelines that the courts use. One is the needs of the child. The court must know how much does this child need for school fees? How much does this child need for medical, house help, food? While it may not be possible to provide in finer details the exact amount, some things like school fees, the court will expect you to provide fee structures and all. Medical, you can get quotation for medical cover if need be, and the court must be satisfied. So one is the need of the child. Number two is the ability or the earning capacity of the parent, and this is very important because I've seen situations where a mother will go to court. Unfortunately, I'm using a mother because you find so often it's mothers who go to court to ask for the fathers to be ordered to provide for their children. So for instance, if a man is earning 50,000 shillings, you cannot go to court and ask the court to order him to pay 100,000 shillings per month. Our courts are courts of justice, and they will assess the capacity of this person to pay. Even if there is no pay slip, the court is in its own way is able to order the father to provide, sometimes we call it affidavit of means, to demonstrate, to be accountable. How much do you make? And based on that, the court will be able to say this father can only pay this much. And it doesn't stop there. Beyond how much he is earning, the court is also able to check, are you being reasonable in what you are asking for? For instance, if an average income of parents is 50,000 shillings, the court does not expect you that you are going to take that child to a school where the school fees is 100,000 per term, because where will the money come from? So the court expects parents, whether even as they demand or for provision or maintenance, that reasonableness should prevail. So that's the second thing that the court will assess, the earning capacity of the parent. The other thing, the court will check whether there's another person who is providing for this child. And the typical example is where, let's say the mother, you have this child, then you get married to a man who is not the biological father of this child. And that man starts providing for that child. He's paying school fees. Again, you cannot go to the biological father of the child and again demand that he pays the same school fees. So the court will expect full disclosure that if there's another person who has taken up responsibility over that child, the court will make a fair order. Probably the biological father may only provide minimally. And by the getting married does not mean that the biological father does not have to be responsible for the child. But the court will not expect you to demand that what is being provided by another father who has taken parental responsibility, that you go to the biological father and demand the same payment. You must be candid and be able to disclose. Fourthly, the court will check whether the man has other responsibilities. And the typical case is where maybe the man, after divorce, remarries and has other children. So you cannot demand that all his income should be focused on this child, because the law does not stop people from moving on. You may also remarry and move on. So the court will look, is this man having other obligations? Is this man raising other children? So that if he's earning 100,000, this 100,000, he has 3, 4, 5 children. And there must be fairness on how the other children are also benefiting. So the court will also look at all the obligations that the man has before it makes an order on how much should pay. And finally, the court will also check, is this a child who has special needs? Because remember, there are children, unfortunately, who need special care and attention. Maybe the child is living with a disability, has a terminal illness. So again, that may contribute to how much the court may order you to provide. So the parameters are many, but the courts are very reasonable, and they also expect parents to be reasonable. So all in all, these parameters are provided for under the law, and nothing stops the parents to present themselves in court and make the necessary demands. And towards the end, we shall see that you don't even need sometimes to go to court to seek an order for maintenance. Parents can enter into an agreement, and the court will only be confirming, or the court will just be registering an agreement on how the parents have agreed to pay. So yes, parents can maintain their children peacefully, but where parents are not able to agree, there are parameters that guide the courts on how that maintenance should be done.